Hello everyone and welcome to today's webinar. Can I just check that those that have joined me can hear me okay? If you can just in the chat box indicate yes or no, that would be perfect. Okay, cool. So we've got quite a small group today, which is fabulous. So hopefully as I go through the slides, you'll think of some additional questions that you may have for me at the end, which I'm happy to answer. So the webinar is being recorded to make you aware of that. It will be available to you in the next few days. So my intention today is to reflect that we are almost 2 years on from the GDPR, and I want to talk you through a 10-question compliance check that you should be able to take away, apply to your business, and see just how well you are in relation to the regulation. So let's start off. So welcome. We're going to talk about what's under the hood of your GDPR compliance. So my name is Kellie Peters. I'm the co-founder of Data Basics, and I've been working in data protection and information governance in public and private sector for almost 20 years. And I'm a little passionate about the subject, and hopefully that will come across in the next 25 minutes of this webinar. So as with every webinar, I just want to quickly touch on the rule book of GDPR, and this will become apparent as I talk through the additional slides, why it's important that we understand the regulation and how it applies to you. So I've condensed a rather large document into one page, and what this hopefully will present is the core basics that you need to think about. And this is what the compliance check will be based on. So you have to be fair, transparent, and honest. If you can't be, you shouldn't be processing personal data. You have to have very clear purposes, and you will have more than one purpose of processing personal data. You need to make sure that you're only collecting information that allows you to make decisions. You shouldn't be collecting more personal data than is necessary. You have a responsibility to make sure that it is accurate and kept up to date. You have a responsibility to only hold on to it for as long as is necessary. You have to keep data safe. And only this week in the news was the story about EasyJet and the hack that they have had. So security of personal data does hit the news, and it's important for us to remember what we can do that is reasonable for our type of business and our size of business. We absolutely have to respect individual rights, and there are multiple rights under the regulation that we need to be mindful of and that we can respect if they are exercised. And most importantly, which hopefully is why you're all here, is to be able to reassure yourself that you are being accountable and you can evidence your accountability. And that's the key thing under this new regulation of 2 years ago, is that evidencing your accountability. So let's take a dive under the hood, and let's think about what are the questions I would ask you if I was coming into your business to see how you're getting on 2 years since the regulation came into force. So one of the first things I'm going to do when I meet with you, or I do as a kind of a bit of investigative work before I step into the initial meeting with you, is I'll look at your privacy policy that you have on your website. It's not the only privacy policy you may have, but it's the one that is the most transparent. So my question to everybody here is the privacy policy that you have on your website and that you provide to your employees, to job applicants, to your clients, is it up to date? Does it still have the 25th of May 2018 on it? Or maybe a little bit before then? So in the past 2 years, have you reviewed it? And within that policy that is on the website, do you very clearly set out the controls and choice that you are giving individuals about how they can find out about what information is being processed on them, why you're processing it on them, and the options that they have should they disagree or wish to complain about your processing activities? if you are relying on consent, and many have relied on consent from a marketing perspective, do you give people the option to opt out or unsubscribe? And is that easy for them to do? Google got wrapped over the knuckles for the fact that they made withdrawing consent incredibly complex. So it's got to be easy, it's got to be transparent, and it's got to be easily accessible. So have your privacy policies been reviewed and amended? Question 1. Question 2 is really about attitude, and it kind of comes in with that accountability principle that I talked about a few moments ago. So is everybody in the business, wherever, if it's only you and you're aware of it, you are everybody. If you are a two-man band or you are in a company of several hundred, do they all know who the data protection lead is? Are they all in it? Are they all aware of what data protection is and how it applies to them as individuals, as well as to your customer base? So some simple checks that are easy to do. Are you registered with the Information Commissioner's Office? Now, this is not a GDPR requirement. This is a requirement of the Data Protection Act of 2018 in the UK. If you haven't, you may have started to receive letters of the intent to fine you if the Information Commissioner believes you should be registered and you're not registered. So most small companies, your fee is £40, and the greater the size of the company you are and the bigger your turnover is, the higher your fee will be to the commissioner. And there is a public register of fee payers. So again, one of the things I would look at is I'd go onto that fee paying database and see if you are registered. Can all your staff identify who the data protection lead is in your business? Because you can have a policy, but if staff don't know what that policy is and they don't know who to turn to, in an event that there is a breach, would they think, oh, I don't know who to contact? Or would they go to their line manager? So think about, do they know who the appropriate lead is, and would they know how to approach them? Do the senior team meet regularly? Now, this might be quarterly, you might do it monthly, and it doesn't have to be lengthy conversations, but do you discuss and assess data protection? So in the current period that we're in with the pandemic, I would have imagined that data protection leads, or those that have a responsibility within their job description, have been talking about new systems that are going to be introduced, the new types of data that you need to be collecting on furloughed employees. So have you been meeting regularly? Is it documented in minutes of meetings? So if I was to come in and to ask, okay, you tell me you meet me, but where's the evidence? You know, is it on an agenda? Is it in minutes of the meetings? And are you then actually taking forward some of the suggested changes? And in the past 2 years, you know, and hopefully certainly in the last 12 months, have you provided data protection training to your staff so they are aware of what their responsibilities are? Because it's not just down to you as the business owner or the leader or the ops director or the HR professional. They all have a role to play in terms of making sure that you can demonstrate compliance and you are reducing the risk of error. And an example of that was in the news about Serco, and a member of staff has inadvertently disclosed email addresses of contact tracers by using the CC box rather than a blind copy box. So one of the questions I would ask there is, when was the last time you trained your staff? And it is a key question that the Commissioner does ask. I would then want to look at, is your register of processing activities current? So you may have mapped your data out 2 years ago, worked out, you know, the different types of systems that you're going to collect and store information. You may have asked the questions, well, where in the world is that data? So not just if it's in the cloud, but, you know, is it based in the US? Is it in Australia? Example. What types of personal data are you collecting? So staff information, client information, supplier data, for example. If you do have staff or you have clients, is any of the information you're collecting on them potentially sensitive information? So law firms may have information that is highly sensitive to some of their clients. HR professionals may have information about employee health, for example. So did you map all of that information, as well as identify the different reasons for processing that? So was it consent? Is it employment contract? Is it a client agreement? But more importantly, whilst you may have done that 2 years ago, have you looked at it recently and have said, is this still accurate? Does this still clearly reflect what you are doing as a business? Because if it's not, remember what I talked about in the rules is that you should only be collecting data that enables you to make decisions. If you no longer need to make those decisions based on the data that you've got in your register, you shouldn't be collecting it. Therefore, you should be making decisions about retention and disposal. So have you recently reviewed your register of processing activities? As I've covered in the last couple of slides, is the lawful basis for processing your data up to date? And in the last couple of months, there would have been the check certainly with employee information about collecting new data and reflecting whether or not you can and cannot collect information about COVID-19 of your staff, visitors to any of your offices, for example. So the question I would be asking you is it still relevant? So one of the big things, and you may remember this, 2 years ago, there was an absolute flurry about this time, a couple of days before. I remember it very well. Masses of emails hitting your box asking you to reconsent. What happened then about 2 weeks later, after the GDPR came in, you suddenly got messages because consent marketing databases went through the floor. People changed their basis to, oh, it's in our interest to collect this information. So my question to you is, when you set up and you determined what your lawful basis for processing was, is it still valid today? Is it still appropriate for you to be using that? And can you demonstrate the decisions that you made about that? So if in the past 2 years you have decided that you're collecting information on a legitimate interest basis, do you have the evidence in the form of a legitimate interest assessment to demonstrate that? And again, that should all be reflected in your privacy policy. So I then got the question I would want to look at in terms of, is your data protection policies. So most policies, whether they be a template or one that you have curated yourself, should have a version control and a date for review. So when you introduced or created these policies in May 2018, have they been reviewed since? And not just by you changing the date, is the information that's in that policy still relevant? And a really good example would be, if you've moved a lot of your staff to remote working, do your data protection policies reflect the remote working and the new ways of communicating with staff and with clients? So do your policies currently that you have in place reflect your business activities? Have you reviewed them in the past 12 months? And if you did buy a templates, and there was quite a lot of companies out there that were selling templates, and you are absolutely entitled to buy those. Is it relevant for your business? So did you buy it and just sign it and send it out, or have you reviewed it to make sure that the content within there actually makes sense to you? So an area that is of a cause of concern, certainly for a lot of cyber insurance companies, is the supply chain, and making sure that where data is going from you to third parties, whether it be software systems or to companies, for example, that you have the appropriate data protection contract clauses in place that you can demonstrate you've taken that seriously, but actually reflect the relationship you have with those third parties. So it's not just CRM systems, accountancy packages, HR packages. It is things such as if you have an external company that runs your payroll for you, is there an agreement in place? Have they demonstrated their compliance to the regulation to you? For example, if you have external HR support, again, do you have a contract in place? And what you then need to be thinking about, if they are using a third party. So I'm going to use an example. If you have an external accountant and they use a software package like QuickBooks or Xero, in that entire supply chain, have all the checks and balances with regards to data protection been made? Because remember, you're the data controller. It's your responsibility to make sure that that is in place, so that if there is a breach, you can demonstrate to the commissioner what you did in place. So 2 years on from when you've done all your mapping and you've used all your systems, are you confident that your supply chain is still relevant in terms of data protection clauses? Or have you taken on new suppliers? If so, do they have the appropriate contracts? And again, can you demonstrate that? Because that's the accountability element, the evidence of that. The next thing is really about the fact that, are your systems, from a technical perspective, able to cope with the regulation, for example? So we have moved on dramatically, and certainly I've seen significant progress in the last 8 weeks of digital transformations, which would have taken months, have now taken weeks, if not quicker than that. So when you chose your system, whether it be a video conference tool, a new accounting package to address the Making Tax Digital, or you've decided you're going to move to a new HR platform, do they support your growth plans? Can you evidence that you looked at the data protection component? So if you're moving from paper or Excel spreadsheets to a HR system that's in the cloud, do you know where that data is stored? Do you know how they're compliant with data protection? Do you know how they are going to support your staff's rights in terms of being able to delete data if it's no longer required? And if it's sensitive information, have you conducted a privacy impact assessment? And again, this is about evidence in that. So it's fantastic to move forward with digital transformation, and it's the way of the future, but we cannot forget privacy. So ease of use of a system shouldn't become more important than it having a negative impact on individuals' rights and freedoms. And a good example of that, and the CEO has been very clear about this, Zoom video conferencing said that they prioritized ease of use over privacy, which is why they are now pushing out lots of privacy updates, because it's a popular platform now, and they've realized that actually the technical measures they have in place are not as good as they should be. So are your systems robust? Can they protect the data? Are they compliant with the regulation? And aside from this, I just want to touch on very briefly on a technical perspective. If we use EasyJet as an example, they, by all accounts, had a breach in January and have notified the commissioner now because they've only just become aware of that breach. If your systems were compromised, how soon would you know that that breach had happened? And is it because software systems hadn't been updated? Now, is that your responsibility or your software supplier's responsibility? But you need to make sure you know that. Remember the supply chain, and then think about, are they equipped to support you technically, and respect the rights of the individuals whose data is going to be stored within those. So the next thing I really wanted to touch on was breaches, because there's been quite a lot of breaches that have happened in the past 2 years. But the thing I want to touch on most is The breaches that don't make the news are the more common ones. So the more common the breaches are things like email going to the wrong recipient. Now, you may never have sent an email to the wrong person, but I will assume that you will have received that, oops, sorry, I didn't mean to send you that email, I sent it to you by mistake. If you haven't, then you've been very fortunate, and everyone you work with is fabulous in that respect. But breaches are rarely a good thing. They can hit the media. The example is, like I just said, EasyJet is very prominent across all the papers on Monday. But you can draw positives from it, so you can learn lessons. So what I'd want to ask you when we're looking at your compliance is, in the last 2 years since the regulation come into force, have there been any data breaches in your company at all? And I'd go as low as, have emails to the wrong people happened? If they haven't, then brilliant. But the reality is there is a distinct possibility that they have. If you're not aware of that, is that because your staff don't know who to talk to? They don't feel that they can put their hand up and say, oops, I'm sorry, I've made a mistake. So when we're looking at compliance, and we're looking at how well you are performing in that kind of GDPR compliance, have you recorded all the breaches that they have occurred? You may never have to report one to the Information Commissioner, but as a company, can you demonstrate the breaches that you have had? Have you learned lessons from them and shared those lessons with the staff? And again, can you evidence that? So is that in team meeting minutes, or is it through posters on walls? Or, you know, we have little handouts with post-it notes that are post-it notes not for passwords. So are there fun ways that you're communicating about how breaches can be reduced, and how you, as the leaders or being responsible for GDPR, can be notified? So have you had any in the last 2 years? If you have, can you demonstrate them? Do you have a breach policy? Do you have a breach investigation process? And do you have a log file? Very similar to breaches, but some of you may never experience a subject access request. You're more likely to experience a data breach than I would say you are a subject access request, unless you're a growing business, or you're very much out there in the public domain and people are aware of what you're processing and why you're processing. So subject access requests, everyone has the right to ask what information they hold, that you hold on them. That includes your employees and your customers and anyone in the supply chain. Some of you may have experienced subject access requests. They are a time-consuming exercise. You're limited in the amount of time you have to respond. So my questions, if I was coming in to look at your compliance, would be, do you have a policy for how to handle subject access requests? More importantly, do your staff know about what that policy is and how to follow that policy? Do you know how many, if any, subject access requests that you had? You know, do you have the same type of one? So if you're, for example, a market research company, you may get requests to remove people that are taking part in online surveys to have their data removed. Or what else do you hold about them? Or how did you have access to their data? You may have been going through disciplinary matters with an unhappy member of staff. They may have exercised their right to access and said, actually, as part of this disciplinary, I want to know everything that you hold on me. So have you had any subject access requests? And a very easy way for me to look at as to whether or not people have reviewed their policies is I will look at your privacy policy and I'll see if you're still referring to the £10 fee. The £10 fee was removed as part of the new regulation, so you can't charge anymore. So do you have processes in place to be able to respond to a subject access request? And finally, point 10, and one that I think people that I talk to struggle with the most is a policy with standard retention periods in it. So at the beginning, I talked to you about you should only keep data for as long as is necessary, and that is what is stipulated in the regulation. So unless you have a statistical or a historical reason for holding that data for forever, you have to have an end date on that. So I would want to look at, do you have a retention schedule? So if you don't have a retention schedule, on your register of processing activities, when you did all your mapping, did you state what your retention periods were? And if so, today, have you reviewed that retention period and disposed of any data that you no longer need because it's outside of the retention period? Prime example, let's take prospective clients. You may have said that you will hold prospective client data for no more than 2 years after the last active contact. So that's opened an email, had a telephone conversation with you. So they've been quiet for 2 years. Your retention period says 2 years. Why would you still have that information today? If it's more than 2 years now, so say it's 26, 27 months, you can have a policy, but do you follow the policy? Are you practically putting in place ways that you can say, let's have a prompt. It's 2 years. We need to make sure we're deleting this data from CRMs, from email systems, wherever you store the data. So do you have a policy on retention? Has it been reviewed? Can you demonstrate? So I'll just recap on that last slide. So I'll just recap on retention just in case you didn't hear me. So you have to have a retention policy. You should be reviewing it regularly. You need to know that once you've hit your retention period, that you can actually then remove the data that you no longer need. And the evidence for that would be your disposal. So is it shredded information? Is it deleting data? Or is it your software supplier supporting you with that deletion request? So in the past 2 years, have you reviewed your retention periods? Any data that you no longer need, has it been deleted? So they're your top 10 points that I've covered. So let's just have a quick chat about what's in your toolbox that you can rely on if you were wanting to audit yourself, for example. So we've talked about the register of processing activities. Now, this may be a Word document, it may be an Excel spreadsheet, but it should set out all the data that you are processing, the reasons why, how you're collecting it, why you're collecting it, the lawful basis, retention periods, etc. Privacy notices are a tool for you to demonstrate that you tell your staff, you tell your job applicants, you tell your customers, you tell website visitors how you process their information. Your breach assessment and log demonstrates that you do understand what a data breach is and you do know how to process that information, and you do know how to notify the commissioner if there was a need to. If you're investing in new systems, you have or you can draw upon your privacy impact assessment, where you are assessing the risk and you're determining whether or not you're going to continue with that system because you know the risk and you feel, based on the assessment, that the risk is low. And you're able to demonstrate your accountability because you can show how you communicate with your customers. You can show that you're registered with the Information Commissioner's Office. You can show your training records of staff. You can show your policies and that they are reviewed. And you may also want to be able to show minutes of meetings, for example. So you've got evidence to support your culture and your approach to data protection. So they're all the tools that you can draw upon. So before I go on to how we could probably help with any of the above that I've talked about. Do you have any questions for me about what I have downloaded to you in the last half an hour? So please use the text box to ask questions. So I've got a question in terms of retention. If you have a 2-year retention period, what you may see when you're reviewing it is that it is not sufficient. So you as a business have to determine what's reasonable if it isn't set down in law. So if you think 2 years is not reasonable, you'd need to be able to demonstrate your decisions behind why you want to extend that and why you'd want to keep that data. But you can't continuously keep every year extending your retention period just because you want to hold on to that data. So I always say, if there's nothing set down in law and it's thinking about customer data, what would be a time frame in which they could complain to you following a transaction with you? If it's prospectus, what's your sales process typically like? And rely on your retention period, and then finesse your retention period over time. So I've got a question about emails between managers that may be discussing performance issues in terms of an employee subject access request. Now, there are some exemptions that can be applied when responding to a subject access request, and those exemptions are typically about if you're making redundancy issues or you are restructuring the business. Other than that, you'll have to provide that information to the individual, but you'll have to redact the other people's names. So the line managers, their details will have to be removed unless they're happy for their data to be shared with the subject access, but the individual that's made the subject access request, which is why subject access requests become incredibly time consuming, because you do need to go back over your emails. So we always recommend that try and take conversations outside of the email system, because typically subject access requests are looking for the conversation in an email that's going to support them. So you can have exemptions, you can redact information, you just need to be very clear to the individual about what you're redacting and why you're redacting it. Are there any other questions for me? So if there are, please do type them in the box. So just a recap in terms of what we could do if you are, this has been a little bit overwhelming or you're uncertain as to your areas of compliance, in particular for certain questions, we do provide data protection support services. We provide practical advice via our website in webinars and blogs, but we also do audits, policy writing, policy reviews. We do provide training for staff. We have a podcast that you might want to listen to. It's like 15 minutes. It's fun stuff. And this week we're talking about EasyJet. I will be talking at Bio because, you know, it's a subject I love talking about, data protection. So we do a lot of freebies. We do webinars every other week. And obviously, if there's things that you don't want to discuss on the webinar, but you'd like to follow up with me afterwards, if you'd like a follow-up conversation, you've either indicated as part of the registration you'd like a call, or you can simply type in the text box message now that you'd like a follow-up conversation with me. But as always, there is absolutely no obligation for that. So with that in mind, so hopefully that has been useful to you. If there are other subjects that you'd like me to cover in future webinars, please do send me an email. I'm always happy to listen to new ideas about what I can talk about, especially as we're doing these every other week now. So please do contact me at any point in time. And thank you very much for joining me on today's webinar. Have a good day.